So this was designed, instead of having to navigate the tribunal process for education, and then on top of that, to enter into the various long-winded routes of complaints processes for the different social care or medical factions. This national trial was designed to be that one-stop shop, the process where education, health, and social care needs and provision were to be all addressed at once. Now, if we look at what the objectives were, let me just get the right slides up. Then they were to create a more holistic view of the child and young person's needs, and to unify appeal rights. So when you've got a system where the plan itself deals with all three issues, why not the procedure which its contents is going to be challenged through? It was hoped that this would encourage joint working between the different departments, and that all of that would then bear positive and more satisfactory results for children and families. So moving on to how this idea was put into practice. Now, we all know that the pilot took place, and that was for 15 months between June of 2015 and August of 2016. Only 17 local authorities took part in that pilot. There were then 30 appeals, and of those appeals, only 9 of them actually went to a hearing. But even from those hearings, it was clear that individuals using the process, and most stakeholders, including the parents and local authorities, supported that single route of redress. However, there wasn't enough data to have that robust assessment of the impact of the trial. They couldn't assess the responsiveness to the recommendations being made by the panels, and whether it was generally a success or a failure. And therefore, the national trial began. So the trial obviously involved all 152 local authorities and CCGs, and it followed the same principles as the pilot. It was supposed to be a 2-year trial from the 3rd of April 2018 to the 31st of March of this year. However, in November of last year, there was an extension to the trial, and that was supposed to be until August of this year. So in effect, there is actually another 3 months officially left of the national trial. So, with the powers, which, as you can see, are contained within the 2017 regulations, the panels only have the non-binding and still have the non-binding recommendations in relation to health and social care provision and needs. They're obviously non-binding because, as the name suggests, it's only a trial, and it's to test the proposed system. And because of that, the government didn't want to have the powers set in stone and make the decisions binding without knowing the true knock-on effect of the use of those powers. But of course, there has been a strong expectation that the recommendations will be followed by the local authorities and the health commissioners, with the opportunity, if necessary, for parents and young people to complain to the Ombudsman and to seek judicial review. Now, the Department for Education actually predicted that initially there would be about 350 cases on the trial. However, up until the end of January of this year, there had been approximately 1,590 applications for appeals on the national trial. There were approximately 7,000, probably upwards of 7,000 appeals in total to this point. So those on the national trial represented just over 1/5 of appeals. Looking at the statistics, of those 1,590 applications, approximately 75% will regard to children and 25 in relation to young people. With health and social care, we had 838 appeals involving both health and social care. There were 354 just involving educational aspect and health, 310 with just social care and education, and only 88 became solely educational appeals once they had started on the trial. I think we can see from these figures that I think it's evident that there hasn't actually been the use of the trial that there could have been. So there are probably hundreds of cases that were crying out for some sort of social care and health input into them, but it just didn't materialise. Now, we know that on the national trial, we know that the tribunal can now deal with section C. So that's the description of the health needs related to SEN. And obviously section any provision reasonably required by the learning difficulties and disabilities which result in the child having SEN. It may also sometimes include, for example, long-term conditions which need management in the educational setting. My next slide deals with some of the reoccurring issues that have been in the tribunal with regard to the health aspects of the plan. You can see there that CAMS assessments, for example, whether they should actually be happening and haven't taken place and should be taking place, and then how to implement the recommendations from any such reports that come out of that assessment. One hot topic has also been in relation to cognitive behaviour therapy. Sometimes it is already agreed before tribunal and ends up in either health or educational provision. But there's often an argument when it gets to tribunal sometimes about where CBT should be within the plan. The medical aspect of it in relation to addressing mental health issues is quite obvious. But there's also the argument that therapies such as CBT, which educate or train, so we've got that section 21 argument. So CBT, when it educates and trains a child or young person, for example, to manage anxiety, can be considered special educational provision and therefore should be in section F of the plan. Similar issues have been arising in relation to occupational aspects of occupational therapy and physiotherapy in terms of their assessments and the provision that comes out of those assessments. The same issues about whether parts of that can be regarded as health or educational provision. Much will depend on the case and context of the case and the child's or young person's presentation and needs. There shouldn't be blanket policies from local authorities which place occupational therapy or any other types of therapies in one or the other place within the plan without a proper consideration about what that provision is actually doing for the child or young person. As we know, more often than not, the programmes suggested by the occupational therapists, physiotherapists, have elements of education and training and are designed to make sure that the child or young person can access and meaningfully engage with education. So it's really important that the expert report set out the education and or training aspects of the provision that is required. So the tribunals and parties are left without doubt about which place that provision should be in. Hot topics have also been in relation to nursing support and the various types, including tracheostomy care. So this may be how it is actually integrated into the school day, or for example, there may be issues with regard to training for teaching and support staff in that tracheostomy management. I'll move on to the social care elements. So we know that section D of the plan deals with the description of social care needs related to SEN or disability. And then we have section H1. So that's the social care provision, which must be made for a child or a young person under 18, resulting from section 2 of the Chronically Sick and Disabled Persons Act. The social care services that can be provided under the 1970 Act are they're wide-ranging. For example, the support at home, support accessing the community, accessing recreational activities. Of course, there's also respite, and this can also include adaptations to the home. And we've also got section H2, which is the any other social care provision reasonably required, again there, by the learning difficulties or disabilities. In practice, this section may also be descriptions not linked to SEN, such as reference to child in need and child protection plans, but by consent. So now we'll turn to look at the recurring issues with regard to social care. So just picking just a few of these on this slide, there can sometimes be a reluctance for parents to request a social care assessment and get social services involved within the case. But sometimes it has to be remembered that the request can be beneficial because it may result in qualification for services from the local authority that benefit the whole family. For example, one example could be respite. However, during these proceedings, it's obviously not uncommon for local authorities to receive a response from social care stating this child is not known to this service, and then there's nothing further. That simply isn't satisfactory. They need to be probing the social services department a little bit more and to get them engaged in the case a little bit more. There needs to be some review. So in those cases, we often get parents having to engage their own independent social workers and or provide their own evidence on the social care aspects. And that can be their evidence using supporting evidence from child support workers or TAs, teachers, youth workers, and then there may be aspects of from the usual reports from OT and psychologists, for example, that may have already been obtained that can help to build their case for some parts of the social care provision and description of needs. If sometimes you get to tribunal and if there's not enough evidence about social care needs and social care provision, but the need for that provision is clear, you do sometimes get the tribunal recommending, obviously, that a social care assessment is to take place, but also they recommend the timescales for that to also be happening. I think there has been a question in the thread about what happens when the local authority has a social worker and the parents have an independent social worker, and there's obviously a difference in their views. Well, in that scenario, it goes down the normal tribunal route where both witnesses, experts, give their evidence in relation to their views of the case, and they are questioned by both parties, by the tribunal, and then it's for the tribunal to sit down, determine, and make the recommendations based on the evidence that's been presented at the tribunal. Another point that has been coming up within the tribunals has been the need for social workers to contribute to the EHCP review and planning meetings. Essentially, that the assessing social worker should be attending and contributing to the EHCP reviews and planning meetings. It's clearly set out in the Code of Practice, but it's something which often isn't included in the plans, but can and should be. At the bottom of the slide, you'll see that sometimes a reoccurring theme is residential placements versus alternative education and social care packages. So this is where there's a residential placement versus the local authorities' sort of combination of college and supported living placement with wraparound social care with support workers. But there is a need to actually look at whether that sort of package, whether that can really be meeting needs in such a fractured way. So those are the issues that pop up in tribunal. Those are the issues that have been popping up, but the question is, has the trial been working? And the answer to that is mixed. Yes, it has in lots of respects. You will recall the objectives that I set out at the beginning of this talk. Are they being met? Well, yes, in ways. The national trial is being utilised effectively to resolve disputes in all three areas, so education, health and social care. So the desired joined up approach to challenging the EHCP is working. It's allowing parents and young people to avoid that three-way complaints process. In many cases, there is a holistic assessment. The local authority and parents are forcing, in bringing these appeals, are forcing the local authority to look at children and young people holistically. There are many cases which also do not reach tribunal. We can't forget those. And that's because there has been that coordinated approach to assessment and planning. So it has worked effectively at that early stage. In some cases, it's forcing the gathering of relevant evidence and explanation, because a local authority is knowing that the case could potentially go to tribunal, where they would have to answer some serious questions. So another objective is being met. There is evidence of collaboration and joint working within local authority departments, as well as health organisations. But I think we will have to accept that the extent of that cooperation does vary between local areas. I think, as Charlotte has mentioned in her talk earlier, in some cases, because the national trial deals with social care and education, and it is that joined up approach, it can act as an instigator for the earlier consideration of costs arguments. The LAs are, at times, really weighing up the cost of provision across the board. So to make an informed decision about whether to challenge or to concede. Going back to the example of the residential placement versus the college and social care wraparound care, I've had cases where, when you do look at the figures clearly, there isn't that cost disparity that has been suggested. In a particular case I've had quite recently, because of the different sources of provision that the local authority were having to arrange, when you do drill down into the figures, as Charlotte suggested earlier, In this particular case that I had, the costs for the local authority were even greater than that residential placement they had to concede. So that joined up consideration and looking at the child holistically can sometimes make unreasonable public expenditure arguments crumble. But if we have to be completely honest, there are aspects of the national trial which are not working. There is the fact that you fall out of this adjudication system if you resolve the educational aspects of the appeal. Therefore, the actual need for there to be an educational aspect to the appeal rather defeats the object of the joined up one-stop shop approach. Another issue is that some local authorities still do not have that coordinated approach. However much you push them, however much you know that, let them know this is definitely going to tribunal, the lack of evidence gathering is a stressor, and it sometimes just doesn't happen until they are before the tribunal, where they are being shouted at and the tribunal are having to make recommendations without the correct evidence. So that is still a problem. The national trial has, of course, also been affected by the adjournments, lack of judges, and the lack of suitable venues. But has this been resolved? I know that more judges have recently been recruited and have actually been chairing hearings already. And as we know, the video hearings have been successful in clearing some of the backlog. I mean, earlier in a few weeks ago, there was a suggestion that it had been doing this quite effectively. We have already heard from John about the problems and the good things about video hearings. In my own experience of these video hearings, they have been positive. However, as John does suggest, it does take a greater level of coordination in order to make it function well. Pre-agreement about outstanding issues is key, and sufficient breaks to negotiate and or speak to witnesses during the hearing is also key as well. And I have found it very helpful to have an open dialing conference facility for the whole day, so that you can discuss things with witnesses and other parties when there are breaks from the tribunal. So, subject to improvements in technology, it may be a suitable fix in relation to certain types of hearings. So, in another aspect where it's not quite working is in relation to costs. Of course, because of the national trial deals with extra elements, they are set down as 2-day hearings, which are more costly generally. The extra day, the extra issues, the more witnesses, higher time, emotional and financial costs for everybody. And it's of note that the local authority can have reasonable costs reimbursed of up to £4,000, not including legal fees, but £4,000. But there's no real similar support for parents and young people. So there's a disparity there. So where are we now with the national trial? As I said earlier, the national trial has actually been extended until the 31st of August of this year. IFF Research and Belmana have carried out an independent evaluation of the trial to inform a decision on whether the trial tribunal recommendation powers should be continued after the trial formally ends. Their evaluation has included in-depth interviews with national stakeholders. It's included case study visits. So I think they visited 12 areas in that case study analysis. There have been surveys of appellants. There's been an analysis of response to recommendation letters, which I am very interested in. There's been an online survey to collect cost data from local authorities and CCGs, and there are also cost case studies, so comparing the journey of a case involving health or social care issues within the national trial. So the focus of that report has been the impact of children and young people's health and social care outcomes, the impact of the whole process for families, how the trial has impacted on LAs and CCGs, additional costs associated with the trial and whether it's value for money, whether the trial has been implemented as intended, and whether there have been any wider learning points. So in terms of next steps, ministers were actually supposed to be making a decision about what happens to the national trial, as I've put here, just after Easter of this year. But of course, the coronavirus has delayed this, and consideration of the national trial is lower down the list of the government's priorities at the moment. In any event, it's my view that the decision likely to be made is to probably further extend the national trial in the short term in order to continue the review and the analysis process, which they probably haven't quite had enough time for now. But then ultimately, they are likely to adopt the trial. If they do adopt the trial, I would suggest some improvements and changes. To start with, I'd like to see, as I've put there, orders to replace recommendations. So in essence, binding decisions. The relevant evidence is being gathered to support decisions. We know there is the specialist tribunal with specialist members to make those decisions. They should be binding. If they are binding, it's of course also means that if there's a further challenge to health and or social care, that this can be at the same time and in the same forum as the challenges to education, rather than having parents needing to go to the Ombudsman or to judicial review proceedings. With that in mind, hopefully there can be a freestanding health and social care appeals regarding the HCPs. It follows that if the tribunal can make orders, then sole or joint issues about health and social care in the plan should be before the tribunal without the need for an educational element to it. I've also put here improvement in case management. So by that, I just mean a better identification of remaining issues prior to the hearing, so that a realistic timetable can be set. And that could include specifically whether the 2 days are needed, and whether witnesses' attendance could potentially be split if necessary or required. Of course, it's helpful if all witnesses can hear all the evidence, but it may at times be more efficient and cost effective if particular witnesses could be scheduled for one of the days. I've also put there more judges and more venues. Well, I think we've already covered this with my previous slide where I said they have recruited more judges and video hearings seem to be working. But adjournments are not helpful for anybody. The jury is still out as to whether this problem has been resolved in the interim period through that recruitment and video hearings. But we shall see. Well, those are my thoughts on the national trial. In essence, it seems to be working. There are things that need to be improved, but it looks like it is set to continue. Thank you.